Before murder cases are wrapped up and investigation papers submitted to the Attorney General's chambers for scrutiny. It is the Attorney General's chambers which decides if prosecution should follow, while the police are merely tasked to conduct and wrap up the probe. Correct me if I'm wrong, Mr. Arunan.
Yes, you're absolutely right.
All right. With us in the studios on Nightline today is lawyer Arunan Selvaraj. He's a defense counsel and he's been involved in numerous criminal cases. Thank you for joining us here to help us shed some light into the processes of law that takes place before a case goes to court. Now, first up, Arunan, is what actually constitutes a strong case that can be brought to court in which the AG would say, yes, this is a case that should be prosecuted?
Well, in a criminal case, the burden of proof is actually beyond reasonable doubt, which means the burden is very high. So to constitute a strong case would mean having sufficient evidence. When I mean sufficient evidence, I say conclusive evidence. That is clear evidence that shows conclusively that this person committed the murder.
That's very good. Conclusive, clear, sufficient. But what are these little pieces of evidence that actually make it an airtight case, so to speak?
Yes. So it's actually a chain of causation. So it's a bit of everything, the whole chain of causation being linked together. And in criminal case, there's two other very important elements that needs to be proved. One is the mental element, that's called the mens rea, and the other is called actus reus, which is actually the act itself. And then comes all the other evidence, which is the murder weapon and maybe a confession by the accused and maybe DNA profile and things like that.
All right, so with all these evidence, among them, I would say a pretty strong one would be admission or confession by a suspect or an accused. Wouldn't that wrap up the case straight away?
Oh, I wish it was as easy as that.
Not that easy?
Not that easy, no. It's because, like I said earlier, it's a chain of causation. So it's the confession is only one part of the evidence. And in many cases, what has happened is that the accused initially, when the case, when the statement is taken from him, he admits to it. And then later on, when the trial goes on, what happens is he denies it, and he says that he said it under duress. He was beaten up by the police or something like that. And what happens is a trial within a trial. It's known as a voir dire. So this is conducted within the trial to establish whether his statement is voluntary or not.
And this is all regardless of the other evidence which may be strong. Like, for instance, we've had the abolition of DNA being used in courts in cases of crime cases and such like. DNA, does it actually constitute a strong piece of evidence, or does it have to be linked with other evidence to make it an airtight case?
It has to be linked with other evidence, because DNA doesn't actually prove that the murder took place. It is only a link. It just shows that it's not conclusive. It's conclusive that it establishes the link of the victim. You see, so it doesn't really show that the murder took place.
All right, so it only serves as a conclusive link for a certain physical item. It could be a weapon, it could be a person, or identity purposes and such like. Now, does DNA actually make solving a case faster with the technology that we have today?
No, it's an additional piece of evidence, and that's it. So it doesn't really make it faster, but we can't just rely on the DNA, but it's an additional piece of evidence which actually helps solve the case.
All right, my next question, Arunan, is if a suspect, or suspects for that matter, are linked to more than one case, assuming there's a case going on now and we have a suspect who's linked to 2, 3, 4, or 5 other cases, then there would be a simultaneous probe. Wouldn't this make it more complicated for the case itself?
Not really, no, because what happens is each case is handled independently. So if a person is a suspect for a rape case, and then the investigation be on the rape case, and then on the murder case he'll be investigating on the murder case. So it's all independent.
Are you saying that basically it would be a different team probing, say, the rape case, which happens to be linked to another, say, a theft case? Totally different team?
Not necessarily. It really depends whether you're going to be charged in the same area. If it's, it all happened in one particular area, then one team will investigate the whole thing. And then they'll decide whether there's going to be 2 charges or 3 charges, whatever.
I see, but in common practice, is it the same team or is it 2 separate teams?
It's the same team.
It's the same team, and which is well and fine, because sometimes you would have 2 or 3 cases which are being probed concurrently,
yes.
And they would have evidence that could be used in the other case as well.
Yes. What will happen is once the probe is done, it's sent to the AG's chambers, and they will evaluate all the evidence before then, and they will decide on what the charges to be charged.
So basically, if there's a multiple probe, it's not really complicated at all.
Not, no.
Doesn't it sort of like expand the team that's required because there are multiple cases involved?
Yeah, of course, it might expand the team, but that doesn't mean it makes it more complicated. It's because the charge is all done independently.
Okay, now we've heard a lot about remand order. When is a person remanded? And for how long? What's the remand period?
Okay, what happens is when a person is accused of something, within 24 hours, the investigating officer, that is the IO, is supposed to take him to the magistrate.
All right.
He's supposed to be brought before the magistrate and ask for a 7 days extension period for the investigation to be done.
Within 24 hours?
No, from 24 hours, he's supposed to ask for a 7 days period.
I see, okay.
If he requires 7 days, he's supposed to bring his diary and explain to convince the magistrate why he needs 7 days to investigate. And if the magistrate feels that 3 days will suffice, then he will just the magistrate will just give him 3 days. If not, it's 7 days. Now, once the 7 days is over, and he feels that he's still not satisfied and he's unable to finish his investigation, then what will happen is he will ask for an additional 7 days.
I see. And that is when, that is the final, or can it be extended another 7 days?
Maximum is 14 days.
So and what you're saying, Arunan, is after 14 days, whoever is doing the probe has to have an airtight case to bring to the AG's chambers, or he's got nothing.
Yes, he's supposed to take it and hand it over to the AG's chambers, and it's for the AG's chambers to decide and evaluate and assess and to see if they have a strong case.
Okay, Mr. Arunan Selvaraj, thank you so much for chatting with us and, of course, shedding light on the actual processes of law. It seems more complicated and difficult than we all envision it to be.
Thank you very much.
All right, moving on to other home news.